Hi, good morning, ladies and gentlemen. It's a pleasure to host this event today, which is a part of the Horizon 2020 Recreating Europe project. As you can see on the screen, we members of the Work Package 6 are visible for a short period of time. Let me quickly introduce the presenters and participants of this workshop today. Even though we have already missed István Harkai on the left side, he will join us very soon. We also have João Pedro Quintais from the University of Amsterdam. We have Christian Katzenbach from Berlin. We also have João Carlos Magalhães from Berlin as well. You can practically see Martina Torm as well on the screen. She will help us quite a lot in organizing and managing this program today. And on the bottom, you can see wonderful colleagues from Denmark, Thomas Ries and Sebastian Schremer, and they will join us for today as well. My name is Peter Mazei. I am one of the co-hosts of this event, and the main reason why I talk first today is very simple. Historically, if it's history, we plan to have a very interesting workshop yesterday and today in Szeged, Hungary, and this Horizon 2020 workshop was planned to be a part of that project on the 5th of May. As everyone knows, the global epidemic made it impossible for us to organize this event in person, and so we decided to have a virtual workshop for today. And this is the main reason why we used AnyMeeting as well, which is a very nice platform. I wanted to tell you a few words on housekeeping rules, which are very basic. We are planning to have 4 presentations today. By the way, sorry, I need to switch the screen, and you can see the presenters on the screen as well. So we are going to use this AnyMeeting today, but we are planning to upload the presentations at the end of the program to Zenodo as well. We are planning to have a Q&A session during and after the presentations. When I say during, I mean we all have to listen to the presentations first, and then we will manage to raise 1 or 2 questions, the most important ones, to the presenters. And at the end of the whole event, we will have the remaining time for Q&A as well. So please feel free to raise your questions in the attendee chat. You can see it on the left side of the screen. Nevertheless, let me emphasize that we are also trying out AnyMeeting for the first time, and we hope to be able to manage these questions quite fairly. And without further ado, let's pass the word to João Pedro Quintais, who is our work package leader and at the same time the other co-host of this event. So João, the floor is yours. We are listening to your presentation.
Okay, Peter, thank you very much. Welcome everyone to this different format of a presentation, of a webinar. We will briefly, this is on the menu for today. I will briefly introduce you to Work Package 6 and then give you a briefish state of play on the Article 17 of the DSM Directive. And then afterwards, Peter and István will talk about the methodology part of their project, of their sub-project, comparative analysis of national laws and strategies on intermediaries in the digital single market. This will be followed by Christian and João's presentation on emergent structures of platform governance and copyright. So very interesting presentation also on methods and challenges. And at the end, we'll have representing our Copenhagen group, Sebastian Schwemmer, that will discuss the evolution from voluntary to mandatory copyright content moderation. Now, the title of our work package 6, and this is the terminology in the Horizon 2020 projects, everything is in work packages and in tasks and subtasks, is Intermediaries, Copyright Content Moderation at Scale in the Digital Single Market, What Impact on Access to Culture. So very briefly, what we are trying to do is an interdisciplinary research here with legal scholars and also researchers from social sciences, but even legal scholars with some knowledge about social sciences, and try to integrate it in particular. We already met the team, of course. Unfortunately, not the most diverse team, but we promise that the project as a whole is quite diverse. And importantly, I think what's important to know, we're going to talk about some preliminary work, but this project goes on for 33 months, which is a little bit less than the duration of the entire Horizon 2020 project. If you have then questions afterwards about this, we'll be happy to address them. Now, particularly in this work package, what we're trying to do, and I lost my presentation, so if Martina could address that issue. I don't know if she can hear me, but my presentation has just disappeared. So what we're trying to do while she tries to solve that issue, hopefully, let me just try to see if we can reopen this again. Sorry, guys. Oh, there it is. Sorry about that, technical glitches. What we're trying to do is to explain, critically examine, and evaluate existing legal frameworks that shape the role of intermediaries in organization of the circulation of culture, including here what we call content moderation. We're also looking at practices and technologies to deploy the circulation of culture, including, again, content moderation. I'll get to that in a second. And we're trying to look at how the legislative framework conditions will shape private models that also affect these particular rules. And as we explain, critically examine, and evaluate, we're also trying to do a bit of, on the empirical side, a lot of measuring this impact of this legal framework, but obviously not only the legal framework, also the business practices and the technologies. And you'll see that João and Christian will discuss this a little bit. Now, important concepts to have in mind as we progress through today's webinar are the concepts of intermediaries. I will not go into very deeply here about this because all of us in our presentations will mention it. But mostly what we have to bear in mind here is that there's a reality pre the CDSM directive, the Copyright and Digital Single Market Directive, and there's a reality post the directive, right? Basically, the reality of Article 17. And then there's a reality post that, which is the broader context in which we are now, which is this movement on tackling illegal content online started by the European Commission that's going to end up as one of its major touchstones with a review of the e-commerce directive in the form of what now seems to be called, finally, the Digital Services Act for some reason. Importantly, also for our research is that although there's a legal notion or several legal notions of what intermediaries might be from a copyright perspective, that's not necessarily harmonized concept across different disciplines in the social sciences and humanities. So there's also a non-legal understanding of intermediaries that we'll have to try to tackle, and that creates problems for the legal analysis too. On the point of content moderation, I think this is also a concept in flux, but what we'll be looking at is at platform governance and content moderation. So we're going to be looking at structures and activities, particularly ones that are covered in our projects, our platform policy and documents, terms of use, community guidelines, but also different levels of practices and technologies. And those include all of the things that you'd expect under Article 17 and under the current regime of the e-commerce directive plus the InfoSoc directive, removal, blocking, filtering, if you want to call it that, contents, pre-publication screening, all those sorts of activities, but also the technological measures, algorithmic moderation, how this affects these, and moderation practices. Now, what's important to note is there is a broader legal debate that Sebastian will mention a little bit, beyond the concept of copyright as a type of illegal content in the view of the Commission, but also differences across disciplines in the areas of platform governance, in the areas of fairness and transparency, and also very, very important to note that all of these are complexly entangled. And I think this is important to note. So I think there is, in the chats, there's an attendee mentioning that he cannot see anything there. Peter is answering. Hopefully that will be solved soon, so I'll continue here. So what I wanted to mention is we're trying to also look at these cross currents in policy and in different areas to understand how they would affect copyright in our research question. Now, my particular presentation, beyond what the work package is doing, is sort of something that I will move through quickly because it's to give you an impressionist view of where we are now with Article 17, how we got here, and the state of play. And that will serve as a baseline for the subsequent presentations. So I'll go through a lot of materials quickly because we looked also at the list of attendees and we know that all of you are knowledgeable in copyright, so there's no need to go super slowly through this. But if you have any questions, I'm happy to clarify afterwards. So I'll talk about background, where we are today, the mechanics of Article 17, and some issues for our research, and all of these threads will hopefully be pulled by some of the other participants, other speakers as we go. Now, on background, I think the question is, how did we get here and why did we get here? There's always a short story to these things, and in EU copyright law, it's usually about lobbying and politics. As a jest, I put here a picture of Axel Voss celebrating one legislative success from his perspective. Not necessarily the one on copyright, but it was a good picture. So There's also a longer story, and this longer story, I think, can be explained as let's call it as a narrative tool from this opposition of a notion of value gap versus upload filters as two opposing fields. On the one hand, we have this idea that we should oppose types of measures qualified, whether they are or not, as upload filters, because that would hinder free and open internet. But on the other hand, and you have an image from the EFPI, there's this strong policy push towards this idea that there is a value gap. This value gap is not exists in user upload or user-generated content platforms, and they are basically what they're doing is, as compared to other online service providers, in the example here is Spotify, they are paying much less for the content that they host. And as such, there's an issue of fairness here, and this should be corrected. So this is the general narrative. Of course, the problem here is whether we're comparing apples and oranges, right? And in the apple being Spotify and the orange being YouTube in the example that will follow. So in the example of Spotify, what we have under the existing law up to the CDSM directive is an online music service provider that connects the public and copyright holders. Copyright holders on their side, we have authors' rights, record producers' rights, and performers' rights. Authors' rights are usually concentrated in collecting management organizations or CMOs, whereas the other rights of related rights holders are concentrated in the hand of record producers. Now, in the legislative framework, what we have is this is regulated on the part of at least authors' rights and author CMO by a mechanism of multi-territorial license, or the rules of the Collective Rights Management Directive, whereas on the side of the online music service provider and its connection to the public and the copyright holders, these are acts that are regulated by Articles 2 and 3 of the Information Society Directive, the InfoSoc Directive. It's about reproduction and communication to the public. So there's an issue of primary or direct liability here. The issue is a little bit different when you look at YouTube. YouTube is what we would call a user upload or user-generated content platform. And YouTube connects public and the end users in a particular way. Now, from the perspective of end user, it's the act of upload is indeed copyright relevant. So it's regulated by Article 3, mostly Article 3 of the InfoSec Directive, right of communication to the public. And this is covered in the area of primary liability. Now, primary liability or direct liability is mostly harmonized. There's rights, exceptions, and limitations and rules of enforcement that are harmonized in different directives, right? And mostly in the InfoSoc and the Enforcement Directive. The part of the platform is mostly moved to the area of so-called secondary or intermediary liability that's regulated partly in the InfoSoc Directive on injunctions, Article 8.3, but also most of it in Articles 14 and 15 for hosting platforms and for the prohibition on general monitoring of the e-commerce directive. And so what you have is this mixed regime that allows notice and takedown on the basis of Article 14, but also on the basis of the recitals of the directive allows the imposition of duties of care, joined in parallel, in tandem with these injunctions in the InfoSoc directive. And this has led to the application of content recognition technologies that lead to what we will talk about later, these upload filters or re-upload filters. Now, there is this more or less clear line. Let me just check here in the chat if we're still good. There's this clear line or clearish line between primary and secondary liability in new law up to this point. What starts happening, however, in this clear line, the relationship between the UGC platforms and the copyright holder is one where we're talking about percentage of ad revenues shared over the play of some sort of copyright protected content. And there is also some licensing and monetization going on, and there's this regime of trusted flaggers. I think Sebastian will talk a little bit about it, so I won't get into it. But what starts happening through operation of the case law of the Court of Justice is that these liability lines are eroded. So there's especially from GS Media onwards, and now we're going to have these 3 pending cases identified there in red, there's not so clear anymore what's the role and the legal qualification of the activities of at least some user-generated content platforms. And this is the type of tug and pull that is happening here that is causing the regime to change from the current regime to change in the eyes of the court, and we also can discuss this in the Q&A, but that is allowing the policy push for a change in rules too. Now, where are we today? This is the background. Where are we today with this question? Well, today we have Article 17. Whether we like it or not, it's the reality we have, so we have to deal with it. We have had pushed by a rule in Article 1710, stakeholder dialogues, where the Commission is supposed to issue guidelines. We are waiting for those guidelines. We have had 6 stakeholder dialogues so far, and the 7th has been postponed due to this current pandemic. But what we have found in these stakeholder dialogues, and I wouldn't necessarily put this on the Commission, but we have found that they are useful in some of the information that comes out, but mostly unsuccessful in finding an operational solution to the issues. At the level of national transpositions that must occur by 7 June, we have most countries that I'm aware of in public consultation mode, and we have some draft implementation bills either published, like in France, Netherlands, and Belgium, I believe, or prepared and about to be published, we hope, such as in Germany. On the academic side, and I'm a bit biased here because I was involved in drafting one particular recommendation, we have already recommendations for European academics on safeguarding user freedoms. We have also come very recently from last week, the European Copyright Society started putting out comments, including on Article 17 by Professor Senflegan and Metzger, and also the Executive Committee of the LIE as a draft opinion on Article 17. We can discuss all of this if you want. And there's a literature boom that's happening here. There's more and more articles coming out, and I'm sure in the next year we'll see dozens, if not more, of such articles. And at the same time, we continue the number of stakeholder statements coming through. And I think where before they focused on let's adopt or not adopt this provision, now they focus on how do we implement this provision on, or how do we tackle certain issues within this particular provision. Now, I think if you want to know more, I just want to give a shout out here to the excellent work being done by Create. Martin Kretschmann and Ulla Frugal and their colleagues have started this website that aggregates all this information, extremely useful. Also, Comunia, Paul Keller, Teresa Nob, and Natalia has also been doing great work on this and reporting at least what's happening in stakeholder dialogues. And we hope in reCreating Europe also to do a bit of this work to help to the transparency of this type of information. Now, okay, what are the mechanics of 17 very quickly so that we understand actually what we're talking about in this provision? We saw the background, we saw what we are today, what's the legal regime of this provision. Now, the legal regime of the provision is the following. There's a definition of online content sharing service platforms, OCSSPs, terrible acronym, that has both a positive definition. It has to be a UGC platform, has to host a large amount of works, which it organizes and promotes, and there has to be some sort of commercial or competitive effect. The usual suspects fall under it. Not so clear, depending on how I interpret this positive definition, whether all platforms would fall under it, even if they're just pure copyright content hosting platforms. On the other hand, you have a negative delimitation, exclusions, and this is a shopping list of either interests that the legislator found important enough to define as excluded and others that lobbied enough for it, like Wikipedia, that would not make sense to include, and they are therefore explicitly excluded from the provision. If you do not fit the positive definition of an OCSSP, or if you are excluded from it, you are a non-OCSSP platform, which means that there's a bifurcation of regimes. You're not covered by the CDSM directive, and you are still covered by the old regime of Article 3 of the InfoSoc directive, plus the e-commerce directive or whatever comes after it. So this is the first thing that's important to understand here because it also affects our research. The second thing is the what and how of the provision, and this is where things get particularly tricky, so I'll try to make a simple explanation. So the idea is that if you qualify as an online content sharing service provider, you are considered to be communicating to the public. So there's direct liability, independent of knowledge or illegality of the upload. So direct liability, what basically it causes is that the former intermediary in the eyes of the law, subject to intermediary secondary liability regime, is now directly liable. It's clear through the provision that the hosting safe harbor in Article 14 of the e-commerce directive doesn't apply, which means that this is lex specialis to the e-commerce directive. The exception to direct liability is twofold. There's an option one, which is the default, is you obtain authorization. This authorization will cover the non-commercial upload of the end user to the platform. However, as we know, outside a few fields, authorization might be very, very difficult to obtain for all the works that are uploaded to a platform, or even impossible, I would argue. Therefore, there's an option two, which is the so-called liability exemption mechanism in 17.4. This is a little bit tricky. Why? Because there's a set of cumulative conditions. The first of which must be read in conjunction with the first option. So not only you have an obligation of authorization, but you have the best efforts to conduct best efforts to obtain that authorization. If you fail to conduct these best efforts, then the full liability exemption mechanism, the other part of the mechanism, really applies, and those are the so-called preventive measures. Now, this is where things have caused a lot of debate, because the remaining obligations are these best efforts to ensure the unavailability of specific words for which copyright holders provide relevant and necessary information. This is what many people call or say that there's a risk that this becomes upload filters. And then there's an additional obligation that says that you have to have, in essence, a notice and take down regime similar to Article 14, or a notice and say down regime, which some people are calling also re-upload filters. So this is the basic regime, and this is where the problems come in, because if this is indeed the reality and the first option of authorization is extremely complex to obtain, then what we have as a problem here is that a default becomes, if you don't want to be liable as a platform, you institute very strong preventive measures, some would say, in clashing with fundamental rights. Now, of course, on the other side of the provision, there are so-called mitigation measures or mechanisms. That's some of the other speakers will go into, but does include a proportionality assessment and factors, a mitigated regime for small and new platforms, which is mostly window dressing because a few conditions of it prevent it from truly applying. Then there's the question of mandatory exceptions and limitations that I would qualify in some cases as potential user rights, and that's important because there's a balancing between the exclusive right preventive measures and fundamental rights in this provision. There's also a specific ban on general monitoring in this regime. So although it's like specialis to the e-commerce directive, then there is a specific ban here on general monitoring, similar to the rationale of Article 15 of the e-commerce directive. And then there are some sort of safeguards for complaint and redress that we'll also discuss further in this webinar. Now, in sum, I think this is how I would qualify. We have a mix or a hybrid between the apple and the orange here as a result of this provision, with a lot of interpretation problems for lawyers, but also in practice, how do you apply this in practice? Now, to finish up, I would like just to point out some issues for research that will be picked up by from some of the other speakers. Now, let me just check your time. I think we're still in time. We are. I got a thumbs up. Now, very quickly, there is many more actually problems than the ones I point out in this particular slide, but what I would like to point out for our particular project, but also for implementation at national level. So we have bifurcation of legal regimes in the InfoSoc directive, e-commerce directive, or the SA on the one hand, and the new copyright directive on the other end. That will also mean different concepts and definitions of platform, unless the ECJ comes in and fully harmonizes it, which will not be the case, because they were talking about really different regimes with different characteristics. Even if the Court of Justice comes with its principle of effectiveness and doctrine of autonomous concepts of EU law, it will be near impossible, maybe after 40 cases, that we get to a purely harmonized regime here. Then there's the issue where I've written with Martin Usuvek on this. We're revising a paper, but there's a huge discussion on the actual nature of the right in Article 17, not just if it's an exclusive right, but actually if it's part of the general concept of communicate or right of communication to the public under international law, which I think pretty clear it is not, in my view, but also under the InfoSoc directive, which there is more debate. I have my doubts. There's pending cases that I pointed out before that will clarify a little bit of this, but I still have my doubt we can discuss this too. Then there's vague concepts. I think at least Sebastian will mention the notion of best efforts. There's the issue of how to assess proportionality factors, the legal nature of exceptions and limitations. Are they user rights, freedoms, defenses? How do they relate to the InfoSoc model provisions? There's the issue of general monitoring obligations. It's particularly problematic because we bifurcated the regime. We have now two bans on general monitoring that the court will have to interpret separately. Will the court harmonize them or not? And how will we deal with the fact that the Digital Services Act might change a little bit to that particular provision? And how will we go forward with that? There's the issue of safeguards in Article 79. We'll also discuss this a little bit further because that touches to the heart of what content moderation is and how platforms carry it out. And then, in my view, an important discussion that there seems to be some debate on the normative hierarchy of the provision. What is first, the exclusive right and preventive measures, or the fundamental rights corporizations in Article 17.7, for example? That will affect fundamentally how we interpret the provision. and then many others. One of them I think I would like to point out, we'll briefly mention it in this project, but there is a potential clash here with data protection law that was not fully understood by the Commission, that just hammered reference to the GDPR and the e-privacy directive. But if this indeed leads to sort of content recognition technologies that automate and collect and process personal data, there might be an issue, at least, for example, with Article 22 of the GDPR. And some people have started writing on this. I'm writing too. I think Christopher Schmon from the EFF has written on this, but it was also a problem identified by some DPAs in the legislative process. So we shouldn't fully ignore this. So thank you very much. That's a very, very quick run through. I hope it's helpful, and I'm available for specific questions if there are, or for the Q&A afterwards. Peter?
Yeah. Thank you, Joao. Actually, wait a minute, just a question came up. Okay, a very long question. If you might take a look at that, Joao, in the attendee chat, just in the last second.
Yeah.
Nevertheless, in the meantime, let me ask all the attendees to feel free to raise questions. And again, as we said, you can raise the questions during the presentation and we can have a chance to discuss them after the presentations, or of course, we will have the Q&A session at the very end. Joe, would you like to answer the question now?
Well, I think I would wait for, thank you, Javi, for your question. I think there's many things that online content. So the question is, as online OCSSPs are generally not obliged to filter and monitor, what other measures are possible for these platforms concerning copyright infringement of their users besides filtering and monitoring? Well, what we're talking about here, the main concern, at least from a fundamental rights perspective, is ex ante filtering and monitoring, right? We're not so much concerned with due process that leads to a removal afterwards, but the main concern is whether they can actually ex ante do that. And actually, contrary to your question, many people do say that not only are they allowed to do this, to some ex ante filtering, if within the remit of Article 17(4)(b, they are actually obliged to do so firsthand. So some analysis actually say that, and I actually don't believe that and don't agree with that. And I think we'll touch upon a bit that later. But if it's not fully answered, then I'll come back to that in the Q&A. Why I don't believe so. Okay, I think
very good. Very good. We have no more questions at the very moment, but again, feel free to raise your questions. And if you don't mind, we will continue the presentation here. And with my colleague István, we agreed that I will be the sole speaker, but you have to know that István did quite a lot of job in this research so far, and to make the presentation as well. Nevertheless, just to make it a little bit smoother, I will talk today. And I'm presenting you what the University of Szeged is willing to do as a part of the Work Package 6. And I need to stress this is about Work Package 6 because we are also a member of the Work Package 2 and Work Package 5. Work Package 2 is about users, and that might have a very important relevance for our current research as well. But in Work Package 6, we focus on intermediaries. Of course, we will have some research on user rights during the intermediary in the use of online platforms as well. But we will separate that question and we will focus on that in a different work package. This presentation today is structured in 3 main parts, although our activity so far includes much more than you can see in the screen, but I just try to be as concise and compact as possible. Today I'm planning to talk very quickly about research methodology, what we try to follow. We want to speak about the scope of our planned research and the schedule of the research. And without further ado, let's start with the methodology as well. You might raise the question why to speak about boring methodology, but you have to know both of us, István and me, are working in the Institute of Comparative Law, and we truly believe that any kind of comparative research must have solid methodology background. Of course, there's no surprises. And we have done quite a lot of research on how to do this activity with respect to comparative copyright researches. And the starting point of our presentation and discussion and thinking is the paper written by Lutz Christian Wolf. And he said in a very recent paper that any comparative research must have 4 main parts: setting the methodological parameters, then a collection of data, act of comparing, and finally analysis. And at the very end of our presentation, you will see how we structured our timeline with respect to these 4 activities we planned and we plan to do. What about methodology? Again, the same paper, although plenty of other research papers speak about this question, highlights that there might be 5 different core questions. We have to set the aim and goal of the research, the question of what shall be compared, the jurisdiction shall be discussed, a very important doctrinal question, how comparability might be ensured. I'm not going to talk about that point today because very simply we are talking about a question which is a harmonized issue, and practically there's no question of comparability. This is given based on the directive of the European Union. And finally, how should the comparative work be conducted? So real methodological processes. And this is the first slide I continue with, and our research is mainly based on 3 main methods. First one is functional method. Actually, these methodological expressions are mainly borrowed from von Höcke's paper. And so again, we base our thinking on the functional method, which is mainly looking for functional equivalence and differences between the legal systems. You will see it very soon what the functional equivalent of our research will be. Method 2 is law in context. So we really want to understand the political, technological, economic environment which form the body of the law. And finally, the key research method for us is the so-called common core method, where we look for commonalities and differences between legal systems in view of the question to what extent harmonization on certain points would be possible among the compared legal systems, or how this question might be answered on a European level to meet the national traditions as well. So we will follow these 3 methods. Nevertheless, of course, this involves in practice analytical activities, data collection activities. We are planning to do various research activities during this presentation, during this research. The next question: what shall be compared? And I think João has already mentioned quite a lot of important things here. But let me stress, we SEGET people do only a micro level research. So others, especially from the University of Amsterdam and Copenhagen, they will do macro level research, so European level questions, and we will have a very interesting research from the Berlin people focusing on the platforms. At this point, we are focusing only on the national implementation and the national legislation and consequences of those national legislation in several member states. We will only focus on Article 17 service providers. Just as João mentioned, it's very open still who fits into this concept, but there are certainly platforms that do not fit into Article 17. We are not going to focus on those platforms, only Article 17 ones. And as I try to highlight, that is going to be the functional equivalent of our research. So we are willing to focus only on these service providers. And of course, we are planning to base our research mainly on books. But of course, since the research lasts for 3 years and the implementation deadline is next summer, we will certainly have quite a lot of time to see, of course, if there will be any, how this question goes into practice. So we really plan to spend quite a lot of time on researching law in action. Next thing, jurisdictions. So what to do research on? And again, based on comparative research methodology papers, we have the understanding that all systems might be eligible, at least within the European Union, but certainly all selections, certainly selection is inevitable. And to highlight, we are required, if it's a requirement, but we made the decision to have only a limited comparison. So we are planning to have a comparison of 9 countries of the European Union, which is, let's say, 1/3 of the member states we will have from next year, let's say this way. And you can see a proposal for the 9 countries on the bottom of the page. I have to highlight that this is still an open question in some sense. We took into consideration various factors like the legal families, language knowledge we have, financial situation we have within the frames of this project. We put some emphasis on GDP, population, global innovation index, and the main regions of Europe, size of member states, as well as something very non-typical research factor, which I call coincidence factor. Practically, this research includes people from various countries of the European Union, Portugal, Netherlands, Hungary, Germany, and Denmark, which is a very important or compelling reason why we really plan to include many of these countries within the selected countries. But of course, we are still open to change some of these countries. To highlight, we plan to have 3 big countries, France, Germany, and Italy. And we plan to have some countries from various parts of Europe, as well as from various legal families. So we, as United Kingdom, will leave the European Union. Let's be polite, we don't need to take a look at the United Kingdom in this research. So this is why we selected Ireland. We are planning to have countries from the Scandinavian region, from the Baltic region. We plan to have a country, by the way, that's Hungary, because that might be quite reasonable to do, as we are Hungarians, from the Central Eastern European region. We want to have a country from the small and medium countries, and those will be Netherlands and Portugal. will represent a medium-sized country from the Latin countries. And of course, as I said, we want to have Scandinavian, at least one Scandinavian country, and that will be Sweden, because it's quite active in this, let's say, platform economy. Nevertheless, we understand that there are open questions and there are countries that might worth the time and energy to look at. Of course, we all know about the Poland's role in challenging this whole directive. We have quite strong connections to Finland. Of course, Spain is a big country, and Luxembourg works as a very nice hub for many corporations that are involved in the platform economy. So we still have to think on this question a little bit to see it quite clearly, that what countries or which countries will be the 9 ultimate countries we are looking at. And if you might raise the question, why only 9? That's very much connected to the financial situation of the project. Practically, this is a research project rather than a project funded by the European Commission to have a comprehensive study on all member states. We have to make our own decisions. So, and we are limited with funding, so we cannot really look at everyone. We have done quite a lot of job, especially Istvan has quite a lot of job in building a database and resources for VP6 as well as for VP2, but we are talking about VP6 here, which includes quite a lot of information on available and relevant books, journal articles, policy papers, and case law. For your consideration, we are planning to launch or provide full and public access to this database in the coming month. We are planning to go through it again and again to be as comprehensive as possible. But I believe this is going to be a very useful research database. Of course, not as fancy as Create's database, but for those who want to have a very quick, easy understanding what we are looking at and what we take into consideration during the research, you can open and you shall open this document. Or actually, this will be a link through. Oh, sorry, we will see what by the way, the project management will require, but we will launch this database as soon as possible. As I mentioned in the beginning of the presentation, we have done quite a lot of methodological activities, and we also thought very hardly what we have to do research on. And again, I might need to stress, we are the SEGET people, so we are doing the comparative research part of this project, which is mainly focusing on the member states implementation. So that really matters. And this is the main reason why we are not willing to look at many questions that, of course, have some connection to this whole field. We are not really willing to deal with the history and evolution of the DSM directive, which is quite a lot of fun, but let's say we will follow a so-called as-it-is approach. We have to accept that it's already accepted. We won't criticize all the politics behind the directive. What we can do is to look at what the directive says and what member states will do. Of course, as I already mentioned, we are not willing to look at other platforms than Article 17, although that's a very fancy question. Of course, we will look at other platforms in VP2, and other colleagues might take a look at other platforms as well, but we are focusing on Article 17 effects, to say this way. We are not willing to focus on the European Union development that much. That will be much more on Joao's shoulders and Sebastian's shoulders. But of course, we will take a look at stakeholders dialogue because that will have a significant relevance for definitional questions as well. We are not planning to look at private ordering mechanisms. That will be up to other guys in this work package as well. We are not willing to look at user rights in practice, so how users might be affected by the implementation of Article 17. Although, again, I need to stress, we will do that, but not in Work Package 6, but under Work Package 2. So this will be quite a lot of schizophrenic situation where shall we report on what, actually, but in VP6, we will only look at the perspective of intermediaries. And finally, we are not planning to focus that much on data protection, only what is absolutely necessary. So, of course, there are data concerns, and we will address them as much as possible. And on the next two slides, you will see what we are planning to do, actually. Just to highlight that we are planning to do something, so not only evading the job, we are planning to do many things. And in this situation, I separated our task into two tracks. The first track is called implementation track, and I call it implementation track because we are planning to look at how member states will implement the directive. And actually, Joao already mentioned various research purposes, like we also plan to take a look at the national implementation of various unclear terms like best efforts or large amounts, high industry standards. We are very much looking at how these terms will be interpreted by the 9 different countries. We are really interested in looking at the final outcome of implementation regarding the liability regime. Will it really be an authorization regime or a focused or a filtering regime? Of course, the priority is authorization under the directive, but we'll see whether member states will implement it so clearly. We also want to look at compliances of the directive with former case law or former norms, including e-commerce, InfoSoc, as well as Court of Justice case law. We want to have a very close look at the role of the rights holders. So whether the quality rights management associations will have a leading role in this authorization, or will there be a meaningful chance for rights holders to individually exercise their rights? How will extended collective licensing be affected or actually put into practice after implementation? And we also want to take a look at how Article 17, paragraph 7 and 9, which are much more about user rights as well as guarantees for the exercising of user rights. Although, as we heard it from Joao, it might be an open question yet whether these are rights at all or not. I usually call them rights, but we'll see. And of course, we are very much looking at the question how compensation might be applied by the member states under Article 17, paragraph 7. And of course, since it's a comparative research, it allows us to compare the 9 different countries. So we are not only looking at the individual implementation of the directive by the 9 member states. We are really willing to have a vertical analysis of these implementations as well. The second track of our research will be much more, if I may say this, much more research oriented. So not that much descriptive or normative or positivist analysis, but much more a research based, research focused track. We are willing to look at direct or indirect consequences. So we really want to see how member states will have a consistent legislation regarding intermediaries, how they will combine e-commerce, InfoSoc, CDSM, and maybe the Digital Services Act later on. We want to raise a question and see whether the value gap will be closed, whether there will be positive economic consequences at all or not. And both Article 17, paragraph 1 and paragraph 7. So whether paragraph 7 will open new ways of remuneration for rights holders or not, whether that will be meaningful, that will be relevant or not. Also, we want to raise the question whether Article 17 will ultimately promote creativity and ensure wider access to copyright protected content online, or vice versa, as many people say it, this will be the end of free internet. Next question, how will member states implement Article 17, paragraph 7? So again, as you all know, paragraph 7 speaks about limitations and exceptions, especially 6 of those from the InfoSoc directive. I'm very keen to see how member states, especially my country, Hungary, will implement the parody exception, for example, or pastiche exception. Because, by the way, Hungary has no parody exception so far. I'm very keen to see whether we will have a general implementation to cover parody for the UGC activities as well as for other activities, or just a UGC-oriented, platform-oriented parody will be introduced in my country. So we look at questions like these. And of course, we also want to keep our eyes on the balance of fundamental rights versus the Digital Single Market Directive. And finally, you won't see these words easily. This is the template we had to use, or I actually use. This is a schedule of the research, but to make it a little bit easier to understand, remember what I showed to you about the main steps of the comparative research mentioned by Lutz Christian Wolf. There are 4 main points, and these questions are, or these parts of the research are separated in terms of time as follows. In the first 8 months, we are setting the methodological parameters as well as a questionnaire that we are willing to use to collect national data. In month 9 to 12 and 19 to 12, we will have the collection of data. Just for your consideration, we will have 2 main questionnaires. The first questionnaire will be before the implementation is due, and the second one will be after the implementation was due. The main reason why we do this way is very simple. We are obliged to have an interim report by the end of this year, sorry, by the end of the 18th month. So we really want to have something. We must have something to present to the European Commission. And so therefore we will need some data. But as you have seen, some member states have already introduced or actually published some proposals or prepared some proposals. So we have some materials, quite relevant materials. Following the collection of data, we will do the act of comparison in 2 different periods, so you can see it on the screen. And finally, we will do the analysis of the findings again in 2 different timings. And of course, again, at the end of the 18th month, we will have an interim report, and following the 29th month, we will have to complete a final report, which will, of course, include not only SEGET findings, but the other colleagues' findings as well. So we will spend quite a lot of time on analysis. And by the way, all of the main parts of this research. And let me put it this way again: we plan to disseminate information quite frequently, but the main outcomes you can expect from SEGED are coming mainly next year and mainly in 2022. I hope you will be able to wait so much, but we plan to do this research quite detailed and at the same time quite well. So we have to, I mean, we need more time. So this was our part. I hope, yes, I hope, I mean, you had some very interesting insights into what this comparative research will be. And I pass the word to Joao again, because I see that there were questions in the chat box.
Yes.
Maybe there will be
Thank you very much, Peter and Istvan. Assuming you can hear me now, there's two questions that we can address now. One you mostly addressed, but maybe we start with that by Axel Balen, sorry, asking, well, will we only have outputs in 2 years? And if I understood what you said, is the idea is that we are transparent about the research and we put things out as we are confident about preliminary results, but the final, these projects work in deliverables, right? So the final deliverable will be later. But I assume the idea, not want to answer for you, would be that, correct?
Yeah, actually, the main focus is on the deliverables, but of course, if there will be some correct and meaningful information, of course, in collaboration with the other members of Work Package 6 and the whole project management, we might be able to show some things. But of course, the main outcomes are the deliverables.
Perfect. So, and then there's a little tricky question. So I hate to put you on the spot, but I love the question by Nevena Kostova, if I'm pronouncing the name correctly. You mentioned, well, we're looking at whether will the value gap be closed, and she mentioned, well, this is interesting. So do we presuppose as a starting point of the research that there was in fact a so-called value gap?
Okay, well, to answer Nevena's question, of course, when I think she didn't mention we, I mean, I guess she didn't refer to you guys and the other ones. Let me say it this way. Again, I'm a researcher, but this time an independent researcher at the university. So say it this way. I have my own personal opinion about the value gap as well, but as I said, my main starting point here would be an as it is procedure. Of course, I cannot lose the sight that there are serious concerns regarding the value gap question as well. When I said we have to look at whether the value gap will be closed or not, I didn't say there is or there was a value gap in this sense, but I believe there are serious issues that the European Union had to address. Whatever you call it, actually, I believe I don't like the value gap word. Okay, so I hate this expression in this sense, but I believe there are inconsistencies in the internet environment, and I don't believe that's the best available approach what we saw so far, to have an independent YouTube and getting quite a lot of funding from advertisers and sharing part of that, or maybe nothing of their incomes. Nevertheless, I have to highlight, I'm coming from Hungary, and in Hungary, YouTube has a very important agreement with authors. CMOs or CMO actually. So we will take a look at the value gap as well. But to answer Nevena's question, I have a stronger belief that there was some kind of value gap rather than there was nothing. Okay.
Okay. Thank you, Peter. I guess this is always a hot topic, but we can also pick it up later on after the remaining presentations with more information. So I would say now, thank you very much, Peter and Istvan. It would be João Carlos and Christian from the HIH in Berlin to do their presentation. And I see them already arriving. Hey, Christian, I'll give you the floor then. Thank you very much.
Okay, thank you. Thank you, João. Thank you, everyone. Yeah, João and me, we will present our sub-project in this context today with the title Emerging Structures of Platform Governance and Copyright, Methods and Challenges in Studying Content Policies. And that might already indicate that we're taking a slightly different perspective on that. We are at least contributing a bit of diversity into that group of white male people and being social scientists and not legal scholars in that group. And yeah, so let me run through a bit what we're going to talk about. I'm talking about agenda points 1 and 2. So the broader context and background of platform governance and our own research interest and our approach to studying this. And then João will then follow up with the more concrete aspects of what we actually do, what we've already done, and what we're going to do. So some remarks on methods, data, and preliminary results. But please note that we are only, as Peter and João already said, only a few months into this project, and that half of that time we are caring for and homeschooling our kids. So there will be only a few results for now to show. Okay, so let me start with the background and what we are interested in. So while Peter and most other legal scholars, at least in that work package, focus on the governance of platforms, so the regulatory framework mostly, at our team, we focus on governance by platforms. So there's, of course, a high interdependency between those two aspects of platform governance and the specific dynamic that we can observe in past years. So there's strong public and political pressure on platforms to take on more responsibility for the content they host. Copyright and the EU directive is one development in this context, but there's much more. Think about hate speech, terrorist propaganda, misinformation, you name it. In all these contexts, the public and political pressure has been really moving up so that platforms act on that. For copyright, Joao, Peter, and later Sebastian and Thomas are analyzing this emerging regulatory framework, the governance of platforms, in detail. But generally, you can observe that questions of platforms governance are now ranking pretty high on the public and policy agenda, at least before the pandemic, but still. And it is indeed an area of high politicization, specifically the debates about Article 17 before the EU Parliament vote resulted, for example, in public demonstrations with thousands of protesters going to the streets. And you must say, I mean, there haven't been many controversies in media internet policy that have caused such a public upheaval. Usually, this is quite an exclusive expert discourse. And in that complex environment, our team is now focusing on the governance by platforms. Of course, in that specific project here, the Horizon 2020 project on copyright, but we also have a broader research agenda that looks at these aspects of governance by platforms and platform governance in general. So here and today, we are specifically talking about how platforms are building up their own regimes of governance for the content they host, partly spurred by that public and political pressure. So let me talk a bit about our research interest and approach in general. What we are looking at is, I would call it the emergence of private platform governance. And this is, as I said already, or indicated a bit, this is a highly dynamic area. The rules, structures, practices, and technologies of platform governance are changing regularly. Currently, for example, we are witnessing this also in the corona situation. For example, Twitter is taking a particularly strong hand in actually positioning content moderation as a means to curb the spread of the pandemic by disallowing content that might help the spread, even blocking content by Bolsonaro or other powerful actors. And there are many more examples in the past where specific developments and controversies have spurred changes in content policies, from the iconographic Vietnam War photo that had been deleted at some time by Facebook, to family pictures of breastfeeding, for example. And all these controversies have changed content policies and also practices in the past. And that is why we find it particularly interesting to look at the process. We're not so much interested in the particular policies they have at a certain point of time or certain platforms, but we are more interested in the comparative perspective, how that is unfolding over time and how that is different between different platforms. And maybe just one final note. You must be aware that this is now an unfolding process over the last 10 or 15 years. And in that time, these social media platforms, or more broadly, these new intermediaries, have established as a key infrastructure of public communication and media. So this unfolding of platform governance can be understood as a kind of institutionalization of a key part of media and communication rules or policy of the 21st century. And that's what we're interested in, to look at this process of the emergence of platform governance. So where can you study that? I mean, this process manifests at very different aspects in many different dimensions. Of course, one aspect to look at is the public and political discourse as a context for that, in order to, for example, to explain changes. Within the governance of the governance by platforms, you can look at the organizational practices of the platforms, for example, content moderation, the content moderators, and how they are working, how they are hired, what are their working conditions, what are their targets for how many images they need to skim through the day. And for example, Sarah Roberts has been doing an incredible job to look at that in detail. You can also look at the technological infrastructures, so the technologies of algorithmic governance, like upload filters or newsfeed ranking. But you can also look at the content policies. All these platforms have a set of policies on their website, and even more now in the past years, they have developed more and more material to explain how they regulate, how they order the content they host. So this is an interesting resource to look at. What are the rules? How are they changing? And that is what we focus on today. I might add that in the second part of the project, we will also try to assess the impact of these emerging structures of platform governance in different platforms over time with regard to the availability and diversity of content and to the creative practices of content producers and creatives. And I think this is especially interesting since the project lifetime equals the implementation of the directive. So we might be able to evaluate some of the consequences of this on this level. For example, of if kind of the fears of the protesters that Article 17 will lead to a much more unified media system than before, if that holds true at the end. Okay, but now we're going to focus on content policies and how they're changing over time and how we are studying that. And I hand over to Joao for that.
Right. Thank you, Christian. So yeah, I'm João. And just taking over here. So as Christian was saying, the project now is looking into content policies. That's what we agreed would be the first moment of our work. And more specifically, of course, as most of research projects, we have a process of data collection and of data analysis. So I'm just going through what we have been doing in terms of data collection. So of course, the first thing was the selection of platforms, and from a sort of social science perspective. So this is not a legal, it's not a perspective from a legal scholar. We decided that we could consider that platforms might be divided between mainstream, of course, for instance, YouTube, but also you could consider that alternative platforms were also a very interesting example if we're looking into a completely different, we don't know yet, but we expect it to be a completely different copyright regime, such as Mastodon, which is not a centralized platform, is in fact what they call some federated platform, or essentially a platform that doesn't go through only one actor, and many actors have power over how the platform works. And then there's a different kind of centralized platform, what we are calling niche platform, such as Vimeo, but there's others. And lastly, we're also looking to industry-centered platform, which João Pedro in the beginning, he was talking about, for instance, Spotify. Once that was defined, we had to understand what kind of policies we would actually collect. And some of them were very easy because, of course, there's a huge literature around terms of services, privacy agreements, or other privacy policies, community guidelines. But what we are finding out, and to be clear, this is exactly where we are in the project right now, we are collecting the data, is that we are finding out that there are like many other sorts of policies that are not on those more standard, I would say, kinds of policies. And for instance, the help page have become very important to tell users how they should behave on a given platform. And I'm happy to unpack a little bit what we mean by that. And then, okay, once the platforms were selected and we had an overall understanding of what kind of policies we were interested, then the next step would be of how do you fetch those documents. And we were very happy, I think everyone is, that some genius some time ago decided to put in place the Wayback Machine service, which is amazing. So Wayback Machine allows you, as most of you likely know, to essentially backtrack and go and see how a given URL has changed over time, or the different versions of the URL. That said, I think that Wayback Machine is amazing, but it also has important limitations. So Wayback Machine is not a completely comprehensive collection of all versions of a given URL. In fact, it might be that many versions are missing. And this is something that is hard to circumvent at this moment, but I think it's an important limitation of our data collection. Right. Then there's a data analysis. So this is really an ongoing moment. We are really trying to understand how to do this, but we developed this sort of an initial way of analyzing how, as Christian was saying, the policies changed over time. And here you can see the kind of categories that we're using to analyze text. And those categories were developed through my analysis, or our first analysis of what the next slide will talk about, which is the Twitter rules, which is the Twitter's community guidelines. But when we were reading the Twitter rules and trying to understand how it changed over time, it got very clear that on the one hand, the legal, it's not illegal, but the policy text, it was either added, replaced, deleted, or recategorized. Recategorized text, it means that something was, in one version was considered spam, and then over time it became, for instance, I don't know, identity. They gave all these sort of different names for the different aspects of the policy. And the second important category of analysis here is the nature of the change. So when we are understanding and we locate a change, some changes, I was a little bit surprised to learn that some changes are purely editorial. They just change, let's say, instead of saying take into consideration, they start saying to consider and things like this. And other ones are what we are calling substantive. Substantive change are changes that are actually changed in the provisions of the policies. And finally, we are developing, again from the ground up, taxonomy of the kind of content that is being changed, or the kind of what the provisions are about. So some provisions, when you look at those policies, part of the policy is usually some sort of principle. So it's not about any specific action, and it's not any specific actor, but it's essentially how the platform sees a certain behavior of the user, of how the platform sees itself. And then there is also users and obligations of both platforms and users. And then there's all sorts of hard to define bits of content. But I think we can, so far we have understood them as definitions. So when the platform is not exactly saying how the platform thinks, but it's essentially defining a provision. So what is a span? So you have like a long definition of what span is. And then you have a different kind of content, which is information, which is really just things like click here to learn more and this sort of thing. And lastly, what I call presentation, which is really apparently completely useless aspects of the policies, but it might be that they have some form of value, such as in the beginning, Twitter rules had a bit of information saying that someone had posted that as if it was a blog post. And then over time, the name of that person disappeared. Anyway, but I think even in the beginning, we can see some of the limitations of this data analysis method. And perhaps the most important one, and I think it's quite debatable, is what configures as a change. So what is a change? So when you can say that there is a change? Because if you see how those policies evolved over time, some people might think that a change is a change of a paragraph or a topic. I think our approach so far has been to break down any change into as many as possible micro changes, so we can have a very clear and detailed understanding of the development of a given policy. So I think the first, we're going to present some preliminary findings of Twitter rules. To be clear, Twitter rules is not about copyrights, and I think this, although this work has been developed in the context of the project Horizon 2020, but it touches on copyrights, but it's much broader. So we analyzed all the 24 versions of Twitter rules since 2009. So there's some content about copyrights, and actually one of the interesting findings is that content hasn't changed much, at least in this particular policy, but the focus is much broader here. So what we found is that there's at the very least 369 changes in Twitter rules in the past 11 years or so. And most of them are substantive, sort of changes in provisions. And when you look at the very basic sort of statistics, or just like a counting up of the contents that were changed in a specific moments over time, you can see that there's some waves, as we are calling them. In the beginning, from 2009 into 2015, most of the changes were concerned spam. So it was a moment that Twitter was trying to understand what, or trying to define what spam is, and there was a lot of back and forth, and it's an interesting moment of the rule in itself. But then over time it became more about the content of what people post on Twitter. So it's not about whether your account is a spam account, but are you saying what the platform expects you to say? And this is what we're calling the moment of policing content. And then from 2017 into June last year, there's been many changes, which we interpret as a long response to the techlash that started after the election of Donald Trump in the end of 2016. And not going into the details here, but it's I think you can see how the platform was responding to very specific debates in the American context. And then since June 2019 last year, the platform has suddenly became just this really short piece of text, what we're calling a bill of obligations. So instead of bill of rights, it's just saying like what users must do and what they have to do on Twitter. And I think the overall understanding, I think one possible interpretation of these waves is that they demonstrate how Twitter has become an explicitly political institution, which is not to say that Twitter at some point was not a political platform, but it has become quite aware of its political power. And I think the other preliminary findings are regarding copyrights policies specifically. And this is, again, ongoing. We are developing this experimental analysis, both me, Christian, and Adrian Cox, who is our research assistant in this project. And so we're just focused on one specific policy, which is terms of services of one specific platform, with SoundCloud. So we are analyzing 8 versions of SoundCloud, of SoundCloud's terms of services since 2008. And again, what we are seeing here is many changes. Even this, it's a way shorter amount of text, but you can see that there's clearly at the very least 40 changes, and most of them are substantive. There's much less editorial change if you compare with Twitter rules. And I'm not going to any finding because, to be honest, I don't think we have one at this moment. But if you see one specific, I found it, I was looking for an example, and I think this one example tells us a little bit about what our method, which is, to be honest, is a very straightforward, not any, it's not rocket science, but it just shows what we can, the kind of conclusion we can arrive at. So if you, I just put this image of how we were comparing the same passage on what the terms of service calls procedure in case of alleged rights infringements, and how it changed between 2008 and 2010. And if you look at, unfortunately, I think it's very small to read all the tiny text, but what's very clear when you see it is that for a reason that I don't know exactly why, maybe it was a change in legislation, maybe something else, they simply added many conditions that someone would have to meet if the person wanted to report copyright infringement. And I think it tells a little bit about how, if in 2008 everything you had to do was to send them a letter and saying who you are and what kind of, who had the rights, etc. But then afterwards was much more specific in all the sort of amount of data that you had to give them. So essentially, to report became much harder, as I said, much costlier. So we're essentially giving just a tiny bit of information about what we're doing. And the next steps, of course, is finalize the data collection. There's a project that we are starting to develop at The Hague, which we have called it Platform Governance Archive. And it's essentially, as the name says, all single policies of all major platforms since ever. All versions of all these platforms. It's quite ambitious, will take a lot of work, but hopefully if you manage to do that, I think would be at least I think a helpful tool for scholars, but also people who don't necessarily study this, but they are simply interested as citizens. And of course, in terms of data analysis, scale up, we have to analyze a lot of things. And in this process of analyzing, we are going to refine our coding frame and actually maybe come up with more specific definitions and things that might be replicated by other people. And I think that's it. Thank you.
Very good. Thank you. Thank you, guys. We have one question to you. I mean, to you too. If you just look at the attendee chat room as well, you will see that. The question was, what theoretical frameworks are you using to analyze the content policies and the changes they undergo? Do you have any chance to answer this question too, Svea?
Go ahead, Christian.
Well, I mean, the broader framework, how we are approaching this is, I mean, I think I already indicated that a bit, is the broader concept of institutional theory, and then discussions about governance research as an interdisciplinary research perspective, and discourse theory. I mean, Joao and I are both rooted in media and communication studies. So we have a special interest, I think, in communication, not only as a means of, as an object of regulation, but also as a kind of means of regulation. So I think one specific aspect that we bring into this discussion, especially in that project, is the perspective that there's more to governance than law. And governance, for me at least, has a different meaning than regulation. It's a broader term. It includes other aspects. It is more akin to the notion of ordering, and in that case now ordering communication. So yeah, that's the broader framework that we are thinking about, and that's our kind of theoretical basis. There's more to governance than law, and we look at the different emerging practices and also content policies over time and across platforms. And one thing to do that is to come from an institutional perspective where we look at processes of institutionalization that happen on many different levels and aspects. Joao, would you like to add something?
I think that's it. And what you said is really interesting because just I think adding to that question is that when we're looking at those policies, they are not only rules, they're also, as Christian just said, they're discourses of those platforms. So platforms in sociological terms and also in institutional terms, they're self-presenting. So it's a form of them to say who we are. And I think that has an amazing and enormous just sociological value if you want to study it, and we try to understand what kind of institution those platforms are, or they can be, or they want to be.
Okay, very good. I didn't see any other questions, so I think you have done your job, and we can pass the floor to, okay, we already have Sebastian, so the floor is yours, Sebastian. Thank you.
Thank you very much, and hi everyone. I'll just quickly jump to our slides. Yes, here we are. I think also the other speakers had a slight lag, so you might not see my mouse moving to what I'm saying. I hope that is not too distracting. I am here for the next 20 minutes to tell you a little about copyright content moderation and the evolution from voluntary to mandatory and what we're working on in this project in Copenhagen. And at the University of Copenhagen, that is us, Thomas Ries, and me, Sebastian Spieme. We are both at the Center for Information Innovation Law. And within the broader scope, or what I'm going to do is, first of all, I'm going to show you quickly what our part is in the reCreating Europe project, where we are. I also want to go back to some of the thoughts that Joao already had before and continue in that vein, adding on our current work on Article 17 of the DSM directive, and then conclude with some insights on where we want to go and where we want this project to steer towards in the later parts of this group. And finally, I hope obviously for discussion, so please write your questions in the chat, and then we also have a bigger discussion afterwards. So what is our part in reCreating Europe? In this work package of intermediaries, there is a first part, which is really the mapping of the regulatory framework. And just as it was just discussed now in relation to governance, I also think the regulatory framework is to be understood much broader than just the law. So it's just not only hard letter law coming from the on the European level or on the national level, but also the very many self-regulatory initiatives that have taken place. So this is currently kind of where we're at time-wise, but in Copenhagen, what we are most interested in, Thomas Ries and me, is really the evaluation of that legal or regulatory framework. So kind of going towards a normative assessment, how these legal rules, both coming from legislation or core practice, but also the contractual terms and practice actually influence the moderation of copyright content on these large-scale platforms. And this evaluation then obviously also hopefully ties into what I think might be one of the very interesting outcomes of our project, namely recommendations and best practices. So the question, if we look at this development and all the different aspects and facets of it, what are best practices or recommendations for handling content moderation in a way that access and the production or creation of cultural artifacts is not harmed. Good. With that, so some brief thoughts on what we're currently doing in Copenhagen. Some of the things I'm going to tell you now are based on a research article that is currently under peer review. And I'm briefly going to touch upon some of the Article 17 issues and broader tendencies. And before I do that, and Joao already did that, but I still think it is necessary, and I'm sure that many of you participants know a great deal about this, but I always think it's important to remind ourselves what is the starting point for this. And this is really kind of the very basic intermediate liability exemption regime in Europe. And what I find quite striking is when we could go back to the InfoSoc directive, for example, from 2001, in the context of injunctions in recital 59, the directive already says that in the digital environment, intermediaries are often best placed to bring infringing activities to an end. And that's because they are increasingly used by third parties. Now, if you think that that statement is 19 years ago, times before we had Facebook, before we had YouTube, before we had Twitter, I think this aged quite well. What's also important to kind of take with us and remind ourselves of is that liability, in principle, is nationally is a national concept and nationally regulated. So the question whether an intermediary is liable for something users are doing is not a question of EU law. It's a question of the national liability standards and concepts. That being said, Article 17, paragraph 1 of the directive now stipulates a direct liability for these platforms for a very specific situation. So there's also on the European level kind of harmonization. And I also think that both the pending cases, YouTube Hamburg and the Puls TV4 case, Austrian case, will be quite interesting in this respect. But as a starting point, so liability is a national matter in a way, whereas liability exemption is on the EU level and in the e-commerce directive. And if you look at the liability exemptions in the e-commerce directive in Articles 12 to 15, I mean, first of all, one important thing to take with us is the horizontal scope of these liability exemptions, meaning that they apply to both civil cases, but also criminal or administrative proceedings. Also very important, it's regarding liability, it's not regarding injunctions, and there might be a very interesting discussion at some point to be taken about whether injunctions might not at some point really be quasi-liability. In order to benefit from these criteria or from these liability exemptions, there are two criteria. So first of all, we need to have an information society service provider. João already went into our online content sharing service providers in the Article 17 of the DSM directive, which is kind of a subgroup of these information society service providers, but also the very basic idea of this liability exemption, at least in terms of non-hosting, so not the platforms, at least in terms of non-hosting expressed in the e-commerce directive, is that these intermediaries really have as an activity only a technical, automatic, and passive nature. The Court of Justice then in the eBay and Google AdWords decision expanded that criteria also to hosting, so that is also part of our platforms when we look at that. There are the three main aspects. We have Mir Concret, so our internet access service providers, and their liability exemption. We have caching, so that's the technical caching, not the caching of your browser you're using right now. And for us, most relevant in this project, we have the platforms read under Article 14 of the e-commerce directive. And as you probably all know, the basic idea here is a liability exemption until a service provider obtains knowledge and then expeditiously acts to remove or disable access to that information. So kind of our notice and takedown regime. And if we think back for a second, so these rules are from 2000. Actually, the e-commerce directive has its 20th birthday in a little over a month. And back then, we didn't have those services and platforms we're looking at now. So it's quite fascinating to see that development. And only in 2015, the European Commission started kind of to more proactively address some of these questions in the strategy for the digital single market, following up in December 2015 already with a communication directly directed towards copyright, and then the proposal for the directive. The proposal, as you all know, went into a directive on the 17th of June 2019. Might be worth mentioning that quite a few member states voted against or abstained, and now has to be implemented until June 2021. What is also interesting is that in parallel, we have two other developments. We have a recommendation, a non-binding recommendation for all kinds of platforms from the 1st of March 2018, and we have a terrorist proposal and potentially a revision of the e-commerce directive in form of the Digital Services Act end of this year or beginning of next year. Now, if we look a little more in detail to the copyright carve-out of Article 14 of the e-commerce directive, first of all, in terms of access to content, the licensing foreseen should also comprise, according to Article 17.2, acts carried out by the users. So users do not have to also get a license unless they generate significant revenues, which is nice. But I think the really interesting question is, what if there are no licenses? João already had a really great overview of the workings of Article 17.4, so this new regime. But as a starting point, Article 14, so a traditional liability exemption, works and doesn't work anymore. And instead, we have this rather complicated best effort regime that João presented to you. Interestingly, I think this is, if you look at the text and also implementation right now, rather chaotic. This is a fun slide from Eleonora Rosati. She compared the language versions of the directive, where best efforts is basically translated into different ways. Could be greater efforts, best efforts, greatest efforts, or all efforts. So quite some confusion there. And if you have closely read the directive, it's quite wonderful. You have recital 66 with a staggering 858 words, not coming with much clarification, but still very nice to read. Now, what I think is one of the really interesting points with Article 17 is Article 17.7, because it says that the cooperation between our relevant platforms and right holders shall not lead to the prevention of the availability of works that are not infringing copyright, so which are covered by an exception limitation. And also Article 17 is harmonizing for the scope of Article 17, at least on an EU level, the rights of quotation, criticism, and review, and the use for the purpose of caricature, parody, and pastiche. And this is obviously a really interesting point that I'm going to get back to in a second. Also, 17.9 is quite interesting from a perspective of access and works, because firstly, these platforms shall actually, in their terms of services, in terms of conditions, inform users that they have these rights. And again, restates that the directive shall not affect legitimate use, such as under an exception or limitation. So as a starting point, this is a quite interesting provision. It might not be so super easy. This is one of my favorite tweets ever, I think, the one on the left side. If you look at it, I hope you can see it. But it's the question, or it's the point that determining if an image is a chihuahua or a muffin is a tough problem in artificial intelligence. And actually, I think that's also the case for me. I have a hard time saying, is this a chihuahua or a muffin? It looks quite similar. The point of this being, if indeed automated moderation is taking place, as you all know, copyright exceptions and limitations can be rather tricky. A good question is whether automated systems even are able to identify that properly. Another interesting point on that, maybe in relation to the Corona crisis, you might have seen that YouTube actually has kind of the content moderation system has changed a little. They rely more on automated content moderation right now. That's not specifically to copyright. It's in terms of all kind of content that is on YouTube. And probably, as Daphne Keller guesses, because they are likely to be wrong when just automated takedown is taken care. And for that reason, a takedown won't count as strike, which would terminate your account. What is then quite interesting is in paragraph 17.9, there's actually a rather detailed mechanism laid out for complaints and redress. And that's both at the platform level, that's at the out-of-court level, and that's at the court level. And I think this is quite interesting because it tells us something about the expectation and the change maybe of perspective in these kind of enforcement processes. Also, there's one little aspect hidden, which I think is quite interesting, namely that such a complaint also should be subject to human review, which obviously tells us that automated content moderation might be the default we're seeing here. So what can we say on this? So first of all, I think let's remind ourselves, good luck, dear algorithms. Copyright limitations and exceptions are really difficult and intricate. Or if you put it another way, maybe false negatives are unavoidable. I think that would be quite interesting to look at. But also, I think the second point on the structural aspects is quite interesting. Namely, we have the internalized balance of copyright law, which is limitations and exceptions. But there's also this additional externalized balancing system of procedural safeguards. And it really tells us in a way also that these limitations and exceptions are the only tool for finding the fair balance between the conflicting fundamental rights in this scenario. And in fact, actually, Article 17, paragraph 7, I think is quite in line with what the Court of Justice has recently found in the Pelham case, the Funke Medien, and the Spiegel Online cases. I also think it's quite interesting to look at the chilling effects and over-enforcement that this might have. So are these services that are being covered by Article 17 incentivized to enforce rather more than too little? I also think something that I haven't addressed here at all, but this whole upstream issue. So this is the downstream issue. Let's assume everything is right, there's no licenses, what is happening then? But the whole upstream issue of the reconciliation with the general monitoring prohibition, Article 15, and also really the case law and Scarlet Extended Netlock, and most recently the Facebook Austria case could be quite interesting. And finally, you may not forget, in practice, much of this has already happened, and YouTube with Content ID really has set both, I think, a high industry standard, but also maybe on the flip side, a market entry barrier. So these are some of the things that I think we should discuss in this part. Now, for the last 4 minutes, let me briefly touch upon some broader mechanisms, which I think are, and tendencies, which I think are quite interesting beyond the copyright directive. And that's for two reasons. First of all, not all platforms are covered by Article 17. So the regime for other actors is still very interesting and relevant. And secondly, I think also from a consistency perspective, it's interesting to locate how copyright might be treated differently than other areas of unlawful content. And as I mentioned before, in September 2017, the European Commission came with a communication which says towards an enhanced responsibility of online platforms, which already gives an indication of that platforms should do more, and mentions, besides many things, that the platforms should step up the fight against illegal content online, but also that platforms probably need a clarification on the liability when they do something proactively and voluntarily in order to be sure that they don't lose their safe harbor, so they're not disincentivized, what is called a good Samaritan action. I touch upon that very briefly in the end as well again. And this has led to a fairly fast follow-up in a non-binding recommendation on content in platforms in 2018 on the 1st of March, which basically addresses all forms of illegal content in Chapter 2. That could also be copyright infringing material, and then specific recommendations in relation to terrorist content, where there was a quick follow-up just half a year later with a proposal for a regulation on terrorist content. And what is interesting, if we look at these, at the recommendation in Chapter 2.18, so in the part of general recommendations for all forms of illegal content, the Commission encourages hosting service providers to take proactive measures, at least where appropriate and where they are proportionate and specific, which could include the automated means for the detection of illegal content, but only where appropriate and proportionate and subject to effective and appropriate safeguards. They look like this in points 19 to 21. You can read them yourself if you like at some point. But what I find interesting is in Article 17, there's really not a question of whether or not this form of enforcement is taking place. There's really the conclusive statement that limitations and exceptions within copyright and the ones that are harmonized is kind of the final balancing factor, and other than that, there's no consideration to be taken whether or not this indeed is proportionate or not. I also think another interesting issue that one can dig further into relates to trusted notifiers and trusted flaggers. They're also addressed in the recommendation, and this is a practice where specialized entities that have special expertise, it could be rights holders organizations, it could be organizations working with child sexual abuse material, have a lot of knowledge in identifying illegal content. And the hope there would be that trusted notifiers flag this content and have a privileged access to take down. And this is something that we're seeing developing both in relation to private actors, so that could be child safety organizations or rights holders organizations, but also in terms of public actors. And what I think interesting to look at here is this intrinsic principal agent issue that is contained there. Finally, a brief outlook. So the European Commission is looking at the e-commerce directive, and there was a leak in the summer last year, which some of you might have seen. So some of the criteria we've seen might change, but also one of the things that's being put forward is to look at this Good Samaritan provision, so clarifying that service providers or platforms that want to do something good, voluntary, for example, content moderation to some degree, should still keep the liability exemption regime. This is also an interesting study where actually Joao was involved from late last year by DG Connect. And you might have seen there's a couple of draft reports coming in from the European Parliament right now on the Digital Services Act, which are worth checking out. Now, for the very last minute, I think that I have left. So this was a very fast walkthrough of some of the things we're currently looking at in Copenhagen. Moving forward, what we're interested in is this normative assessment and then getting to recommendations. And I think, one, there's this relation between platform users and rights holders and the legal rules, the contractual terms, and the practice that we somehow kind of want to look at, and really ask the question, how do the rules and terms shape the design of removal and moderation by these platforms, taking into account role of fundamental rights and cultural rights. We have a couple of methodological ideas, building it maybe on the user-generated law framework that we've used previously. We'll see that. I also think it's interesting to look at this whole question of voluntary content moderation on the one side and mandatory content moderation on the other side. So what are the differences? What does this mean for the access to works? I think there's also interesting discourse to be made on the question of state enacted law versus private regulation, and really also identify what are the drivers that initiate and shape private regulation, because I think that's in the end what a lot depends on. So lastly, we have some expectations concerning private regulation that we're going to test in our part of the project once we have the kind of data collection. I think an interesting line that we want to continue working with Thomas recently is this idea of conceptualizing rough justice, which is what we might see emerging in these content moderation practices by large online platforms. And with that, I think I'm almost over time. So let me just thank you for listening. I look forward to your questions and the discussion afterwards. Thank you.
Thank you very much, Sebastian, for the very comprehensive and spot-on discussion. I think we have one question, at least a specific question, and then maybe we can use your presentation as a platform, no pun intended, or perhaps it is, to move to the further discussion. So Kimani Godard asks, and I think this is, as we were discussing Article 17, so I don't fully know if the question is vis-a-vis national implementations or future reform, or the more general point, whether is a legal recategorization of internet intermediaries as a subcategory of broadcaster with all of the attendant regulatory responsibilities necessary. So in a way, as I see this question, at least as I understand it, is actually, should we be taking it more from the perspective of a subdivision within the subclassification as a type of broadcaster here and bring in that regulatory framework? And I apologize in advance to Kimani if I didn't fully understand her question.
Thank you very much, Kimani, for that question. I think it's a quite interesting one. Let me also try to tell you quickly how I understand it. So the question is in terms of the categories we have today. And I think maybe I should also briefly mention I'm working for the European Commission on a study on the non-hosting environment in relation to the Digital Services Act. And I think one of the interesting questions, of course, is, are the boxes we have, are they still relevant? I mean, the e-commerce directive works with a box of not actually intermediary, it works with a box of information society service provider and a specific service. There's a telecommunications regime, there's a media regulation regime, and it might be interesting to look at how some of the platforms, at least, are not traditional hosting platforms, and there might be other criteria to look at. You can also see this in some of the thoughts being put forward, both in the study where Joao was involved by EVIR, on the question whether editorial functions, for example, should be a criteria to look at rather than an active or passive distinction, which can be quite difficult. So I hope this answers your question at least a little bit, Kimani. Otherwise, feel free to follow up.
Thank you very much. I think we can call the other speakers in to move in, because some questions start popping up, and I apologize in advance if we miss something. But there seems to be a question here. Kimani says thank you, so I think you've addressed our issue. There seems to be a question here: is how member states are implementing, for example, the example that's given here is a parody exception. So if I understand correctly what's in the chat box, and sorry for the cognitive dissonance, the question here is, well, some provisions are optional in the InfoSoc directive, and then there's this special provision in Article 17.7 that's a mandatory provision for the same concept of quotation, caricature, parody, or pastiche. So I'd have to look to each national law, but what I've seen in in the countries that I mentioned that are in public consultation mode is actually that people, or the tendency is towards implementing them as mandatory exceptions. And there's a strong push for the countries that don't have it. For example, Portugal doesn't have an explicit parody exception to actually implement it. Now, whether that's going to go through or not is really a different question. And there's quite a fight right now, even in the academic field, on how to interpret Article 17.7. So I don't know if any of you wants to add to that or not.
Yeah, let me also react very quickly. I believe what really matters here is not the quotation question. Quotation is also regulated by Berne Convention. That's really much present in the member states' laws currently. But parody, caricature, and pastiche is really going to be a big issue. And this is what I try to highlight in my presentation as well, that we are really looking at the question how those countries who have not introduced parody, caricature, pastiche yet, will they introduce it only as a mandatory exception, but from a DSM perspective, but in a general perspective? Just to use one example here, Hungary had probably one of the most, first parody court decision. We had some expert opinions earlier, but we had a parody opinion, decision a few months before last year, and it was published this year, early this year, about the use of Superman's costume design on the cover of a magazine, of a weekly magazine's cover, in order to practically criticize rich people in the country, connected to politics as well. And the main argument of the court ruling was nothing else than that parody exception is not regulated in the law. There's no parody in Hungary, at least no chance to call parody as a way to exempt yourself from liability. But if we look at the DSM directives provision, that's really talking about online content sharing service providers plus parody. This case would not be exempted if the DSM directive would be literally introduced in the country with only a focus on online content sharing service providers. Nevertheless, I also agree that, to me, it seems so that the directive allows member states to introduce parody as a mandatory general exception. And I just wish that will be the case in Hungary especially, but in other countries as well. So we have to take a look at that very much.
Yeah, so I think from my perspective, and I've written this, is quite clear that at least in OSSPs, this has to be a mandatory exception. I don't see there's any legal room for other than that. I think broader interpretations are in order, but at least that has to be. Now, there's also a question here that's a broader question, and how can these filtering and or moderating measures, and possibly others, relate to the freedom to conduct a business in Article 16 of the Charter? And I see Sebastian is raising its hand, so wants to say something. So go ahead.
Yes, thank you. So Ravi, I think this is a really interesting question. First of all, as you might know, João already mentioned it, there's an ongoing pending case before the Court of Justice where Poland challenges the directive. Now, there can be political reasons. Poland is actually one of the two actors bringing direct actions before the Court of Justice. It's not something that we see very often from other actors. But actually, in that, they are not challenging Article 17 based on the freedom to conduct business, but only from a freedom of expression point of view, which I was a little surprised about. Because I think your point is very valid. If you look at the vote in the council, Germany came with a fairly long statement attached to its vote, 5 pages, where Germany actually elaborates on some of these things. For example, the issue of both that there are, copyright is not registered, right? So there's a issue around the databases of data on rights information, as well as the technical aspect, which in Germany is supposed to be addressed, for example, by open source solutions, which I find really interesting. I would love to see that explored more. if you look at the Commission's impact assessment from 2016, you will see that they actually have looked at quite a few different automation systems, platforms, AudioMagic and others, that offer these services and come very quickly to the conclusion that this is something that is easily available for everyone. I think that's definitely something we should, in our project, also look further at, whether that's even the case. So I think the whole aspect of freedom to conduct a business of these platforms can be very, very interesting from a competitive perspective, where especially some of the smaller but not young platforms might be at a disadvantage.
Yeah. I would just add on that point to Lachan on that was highly criticized, this view on impact assessment, because data doesn't really show that these are such cheap measures and easy to implement. So I actually think a point Sebastian makes in its presentation is extremely valid. There's some articles already on this, which is the competitive disadvantage for smaller platforms, depending on how we interpret industry standards. Now, there's another question here, and then I would like to get to that, and then also ask a question to Christine and João. So Natasha Mangal asks, is there any level of coordination among member states in implementation strategies? Are there some similarities appearing in some of the draft legislation that may indicate coordinated efforts? Well, I think given the time we have, this is a long question to ask. I think there is some level of coordination, and I think there's also a fight here. There's certainly an unspoken fight between Netherlands and France in trying to push their legislative proposals before the others, so that it becomes a de facto standard in different directions. And other countries are clearly waiting for the Commission guidelines. And I think behind the scenes in the Commission stakeholder dialogues, you see that a lot. But I don't know if we can go much more in depth into that. I did want to ask to Christine and João, given on your very preliminary results, it seems to me that I was super interested in this because I had looked at it before and we talked before about this, but is it the case that if we add a more complex system, what platforms will do, as they have done so far, is to just add additional rules, additional obligations, and those will inevitably, due to the risk of legal liability, fall upon users, just basically towards tilting de facto towards one side of the equation. So more towards putting preventive measures on rather than allowing users to easily dispute this or even by default have the content up.
I think that's a good question. I mean, we haven't really looked into the whole spectrum, of course, of the platforms. In that particular case that we presented in that slide, I would say that seems to be so. I mean, that seems to be that suddenly, if the user wants to report copyright infringement, apparently the amount of documents that SoundCloud was essentially requiring the person to present seems like fairly, I would say, hard to actually essentially produce. And I think if you go and look at other elements of the same terms of services of SoundCloud, at other moments it doesn't seem to be the case, right? So I think it's hard to say at this moment, but I would say that based on my understanding is that there's no one single trend. There's different trends. So if you look at, of course, then it's not exactly about copyrights, but if you look at the Twitter rules, it seems to be the opposite, or it comes and goes. And that, I think, talks a little bit about platforms' anxiety. And they have it sounds like a weird term, but they have a hard time understanding the power that they have. And so they know that they have a lot of power, but they are not states, so they don't have representatives discussing what to do. It's just usually a very small sect of executives making decisions, usually based on their business models. So yeah, I think it's might be a guess, and I'm happy that you picked it up because I think it might be a key conclusion of our analysis. One question that I have is whether that's only SoundCloud or actually other platforms also did the same. Yeah, I'm not sure if Christian wants to say something.
Well, I think we can't really talk about copyright already because we haven't done enough work to really say about that. I mean, I think the general tendency is that as Joao said, I mean, the platforms are very reactive in a way, and that speaks out of the content policies that you see. So you see a lot of controversies and developments kind of manifesting into these policies. And I'm looking forward to understand and to see how that EU copyright directive manifests into these policies. But how that really will speak out, I think, is yet to be seen. Because I think there are these two tendencies. The one is to kind of hand over more and more responsibilities to the users, making things more and more complex and making also these content policies more and more lengthy. But at the other hand, we've seen, especially in the past 2 years, more and more pressure on transparency and also into explaining what they do. And they have started to diversify the kind of policies they have and the kind of documents and the kind of documentation that they put online, where they also have very easy to understand stuff on how they handle content. So this is really a complex thing. For example, Twitter used to have terms of services and the Twitter rules or community guidelines, but only kind of 2 documents, one legal document and one community document. And now they have really kind of a whole, I don't know, I think 3-tiered website to explain what they do.
Yeah, I think it's like we counted, I think 26 policies or kinds of policies so far.
So I actually wanted to pick that on that point and actually move it to Sebastian, that I saw that you had your real hand up, which is a little bit based on what I've seen and you've seen too, and I think we generally have seen. There's starting from this Tackling Illegal Content Online initiative, where for some reason IP is put next to hate speech and terrorist content, which is in itself a little bit of a strange thing. What you see is like this spread out of different measures, and copyright was kind of the first where you have a real specific regime with preventive measures. But as we see also with the GDPR, with this tiering of policies that Christian and Jean are mentioning, are we to expect platforms to have in-house teams of lawyers to develop 5 or different types of policies for the type of content at issue, rather than having a streamlined reality? And then it's kind of problematic because some type of illegal content can overlap, right? Some can be everything is copyright protected almost, and can also be others. What do you think about that?
Yeah, that's a really good question. I mean, the whole overlapping nature of content, I think, can be quite interesting. Also, if we go back to Article 17.7 for a second, I mean, in a way, it's kind of actually could be seen as a strengthening, right? If we go away of user rights, so to say, if we go away from the perspective of the top level kind of upstream question, whether this is a good idea at all, but at least it stipulates expressly that, first of all, in relation to what Joao and Christian were saying, that these services actually need in their terms to write that you are allowed to use content that is covered by a limitation and exception. And secondly, as there's already practice today, it might actually set some further guidelines for the practice of these services. Now, I would be very surprised to see a similar detailed approach going forward in either of the other more specific content fields. I mean, in terms of child sexual abuse material, there's a directive from 2015, which is also quite interesting because it in many ways doesn't go as far as what we've seen in copyright or in terrorist content or in the online content recommendation. So I would be surprised to see more detailed stuff like that. Also, on your brief point, Joao, it's surprising to put this in context. I mean, obviously, there's a policy spin to it. But then again, we may also not forget, actually, the basic regime, the e-commerce directive, doesn't discriminate between content. The e-commerce directive is not looking at, is this just copyright, so to say? It's a commercial question primarily. Or is this actually harm for individuals? Think about child sexual abuse material. So that might be also some path dependence over there, in addition to, of course, a lot of policy consideration.
Indeed, I agree with that, and I actually think this is probably true. Although we can also see, I've once called this copyright directive as a Trojan horse for these types of measures, because as we review the DSA, the Digital Services, as we review the ECD into the Digital Services Act, there will be a tendency to use some path dependency also on the pre-existing examples, right? And if the example now the default is something like Article 17, then it would be interesting to know if for other types of content the regulation gets detailed or not. Now, I see, Peter, also, there's another question you addressed. Axel is asking if we'll look at business-to-business regulation, basically. I would say, as far as we've discussed in context, regulatory context, but not necessarily in depth of analysis, but for things that are indeed directly relevant. I see Sebastian has also mentioned it. We will have to look at it. It's part of our scope. Now, I don't know, Peter, I think we are at 11 now. So
at 11.
we want to do the honors of the final words?
Well, as the event would have taken place in Szeged, otherwise, I take the liberty to thank all of the presenters, all of the organizers. I'm focusing on Martina at the moment, and all the attendees to help us to make this event, I think, quite useful and fruitful. And we hope to have very reasonable and very good outcomes from this research. A quick note to all those who attended this event: we are obliged to have another workshop in 1 year, so in month 16, which is hypothetically April 2021. Very far away, but those who might found it interesting to listen to us at this initial stage might be interested in listening to us at a much more distant time with much more outcomes, actually. So please stay tuned, follow the reCreating Europe's website and Twitter account and many other places, and we are going to show many of our results as soon as possible. So thanks again for joining us, and have a nice day, guys.
Thank you very much.